All right. Hi, everybody. Welcome to the latest Artist WorkLab. The topic tonight is handling and avoiding copyright and licensing issues or violations. And rather than being a more general copyright for artists, which is a really, really broad topic, we wanted to kind of hone in on this particularly because this can be something that can affect a lot of us. And there's a massive helplessness that happens when you discover that somebody's copying your work, no matter what medium you work in, and then trying to figure out what to do. You're kind of flailing around trying to figure out what's your first step, what's your second step. And so this workshop is actually about helping you prepare for that. And we've got an amazing panel tonight who's going to help us work through it. My name is Jane Davila. I'm the executive director here at Metro Art Studios. We produce these in collaboration with the Cultural Alliance of Fairfield County, with some support from Connecticut Humanities. And our building is 38 studios, 42 artists. We have a number of events that are open to the public on a regular basis, including the Bridgeport Art Trail that's coming up in November, second week in November. And we encourage you to join our mailing list so that you don't miss anything, because there's always so much really cool, fun stuff to do. And I'm really pleased to introduce tonight Erica, who is the new executive director of the Cultural Alliance, and I know she can introduce herself better than I can.
Thank you. Thank you so much. Very happy to be here. I'm Erica Wesley, and I am the new Executive Director of the Cultural Alliance of Fairfield County. We are a membership organization of over 600 artists and art organizations and institutions, and we provide access for artists to one another for networking, convening, and other capacity building opportunities. And we also provide incredible marketing and promotional activities so that all of the artists across Fairfield County and the institutions that are also creating art with community are able to be amplified and recognized for their good work. Very excited to be here. My colleagues will join in a few minutes, but everyone, everywhere I go, has told me that David Green has left big shoes to fill. So I'm going to say it tonight so no one else says it. And indeed he has. And so I walk in his footsteps, but then also walk alongside him as my individual self. Certainly excited to connect with all of you and hopefully to leave a positive impression on this awesome community. So thank you for having me.
So we're going to have, we're going to have our panel introduce themselves to you and tell a little bit about what you do and anything you feel that's relevant to what's going on here. So we'll start with Greg.
All right. Well, good evening, everyone. I'm happy to be here. My name is Greg Kanaan, and I am an attorney. I run a small solo law practice called The Legal Artist, and what I do is I represent artists and designers and creative people. I focus on representing artists, designers, and creative people. I do have other clients who are not in the creative world, but I was a television producer for 7 years. Before that, I went to RISD. I was an undergrad at RISD. I graduated in 2002 from the FAV department, and I moved into television shortly after. I did that for 7 years, and for reasons that if everyone's interested later on I could talk about, I moved into law. I've been practicing now for 11 years. I work out of Milford, Connecticut, but I'm also licensed in New York.
My name's Raf, but I go by Five Fingers. I do the Love More Than Ever campaign, the street art movement around the world. I started that when I was working in Chicago, and I received word that there was some white supremacy flyers going around in Norwalk. So they were like, "Hey, like since you do all the street art and graffiti, can you come up with a saying or something that's powerful to fight hate?" So I came up with a little more than ever after the different trials and going back and forth. And it was like an origin story. Like I do a lot of assemblies around the state in New York City with kids, and I always say it was like a rainy night, and it was kismet, and it came down to these four letters. And I come from the marketing world where I did a lot of graphic design, so it came down to these four letters, four words, 16 total, and it made a perfect rectangular square. And I was like, that's it, love more than ever. Like, should there be a comma there? But coming from the graffiti world, sometimes you just gotta leave that out. And I'm just like, should be a comma, a period? Like, I don't want to get dragged. on social media because I didn't put a comma or period. So then I was like, that's it. I'm just gonna let it be. And when I get home, if the URL and everything is available for it, I'm just gonna go full force with it. Sure enough, there was nothing that ever existed with Love More Than Ever. And I started pushing that, and just my campaign of positivity across the world, wherever I go, I always bring stickers, I always bring stencils. I do a lot of mural work, so I always try to include that into it. And then lo and behold, and again, I could only say so much, but lo and behold, I got home one time and a friend of mine was like, "Oh, congratulations, your shirts are in Dick's Sporting Goods and and they were across the country." And I was like, "What?" And so they were like, "Go to Dick's." So I went to Dick's. Sure enough, they had a whole end cap and rack display with Love More Than Ever all over the place. So needless to say, I went nuts. I grabbed them all off the rack, and I just wanted to walk out of the store. And my girlfriend at the time, she was just like, "No, like don't do that." So I started like yelling at the poor 16-year-old girl cashier, and I was like, "This is mine. This is mine. Like, what are you guys doing?" So it was a bigger issue than that, and I just put it all over social media, and luckily someone helped me out. But we'll speak more on that. But I go by Five Fingers. I'm a street artist. I do Love More Than Ever.
Thank you. Hi, I'm Susan Fehlinger, and I'm an oil painter. I have a studio here in the building, and I've been painting for about, I guess, 20 years. I used to live on Cape Cod, and aside from my paintings, I sold prints of my work in various gift shops and galleries around the Cape. Um, and just a couple of years ago, I found a friend of mine called and said, "Hey, your prints are on Wayfair and Amazon and Walmart and several other online stores." And I had no idea they were being sold. And it turned out my printer on Cape Cod was uploading my work and selling it. And I never had any contract with him for that, and I never got any money for it. So I was quite upset. And I guess my story will unfold as we go.
It will.
But
Yeah.
that's sort of the setup.
So you can see that like our panel is going to be really well placed to be able to give us really good deep information about this kind of an issue. And just to start us off, here are some statistics that I found online about copyright and licensing violation. In 2019, 2.5 billion images are stolen every day. So that's photography, that's everything, right? Illegally used. 23% of those are in the United States. Copyright infringement impacts creators in a number of ways, including loss of income, de-incentivizing creativity, like why would you make something if everybody's going to steal it, and the lack of quality control. People were copying both of your work and you had no say in how it was being done and what kind of materials it was going on, what price was being charged, any of that. It's a loss of control for the artists. 10 to 27% of the work that consumers access right now are unlicensed or unauthorized. So that's music, video, writing. 20% of books that are downloaded are illegal copies right now. That's across all media. So we want to get started by asking a little bit more about what happened to you. And I know you both touched on it, but if you could, both of you talk a little bit more in detail about what happened, how you discovered that your work was being stolen, how that made you feel. Just more in detail about that sort of thing would be really helpful to all of us.
Okay. Okay. Well, I was initially totally shocked. One of my friends said she saw my work on Amazon. And then I did a little research and found out it was on several large websites. And I dug in a little bit to see who the vendor was. And it turned out to be my printer on Cape Cod, who had all my high-res files from doing my prints for all those years. I since moved here, so I wasn't working with him anymore, and I had no contract with him. I did have a contract with him for about 3 years when he was selling my work on his website. At the time, he wanted me to go sell on Walmart, and I said, I don't want my work on Walmart. I feel like, I'd like to think it's a little classier than that. I just, he was putting it on big box stores and, you know, Amazon, Wayfair, all these places that I really didn't want. And he was selling it at prices, you know, he was selling prints for like $46 and $60. He was making them on canvas. You could order what size you want. And he was actually calling it the Susan Fehlinger collection. And he was using my titles and my images, and I had no idea. So I was upset, to say the least. And the way I finally found some sort of solution was I was talking to David Green, and he put me in touch with an organization up in Boston which connects artists with lawyers who will do pro bono work, which was fabulous. So I got in touch, I can't remember the name of that, maybe you know the organization.
Volunteer Lawyers in New York.
It's like that, yeah, up in Boston. And I was actually happy it was Boston because this fellow was up in Massachusetts, so same state was good. And they put me in touch with a lawyer. It took a little bit, but this lawyer got in touch with me, and he was very responsive. He asked me the whole story, and he immediately did a cease and desist order to have this swine take down my work. And we got it taken down actually fairly quickly. The stumbling block, of course, was to find out how much he was sold and trying to get some money out of it. He stonewalled us on the sales numbers. He finally gave us some fake numbers, well, incomplete, I should say. He said he owed me $55 for the last 5 years of selling on all these mega websites. Now, I do better than that in a yard sale in, you know, in Fairfield in a day. I know that that was not true. I also know when I had found out my sister ordered a print and had it shipped to her home in North Carolina, and that was not listed. He listed all the prints and that was not there. So I said, I know it's incomplete because I already know she has one. And we have never been able to break through the money part. He did take everything down, which was good, and the lawyer was great. It's a little unsatisfying, although I'm happy it's not up there anymore. I don't want my work on Amazon and Walmart and Wayfair and all these other places. So I guess I'm sort of satisfied, but not 100%. So I don't know where to go from here as far as the money part, but I'm happy that I got this lawyer to help me out. He was great.
Yeah, I just listening to that. Was that recently?
Yeah.
So that was.
Within a year. Yeah.
Oh, okay. All right. Yeah. So a similar story, like I said, I discovered because friends of mine found them across the country, and I would do a lot of scavenger hunt, art hunts where I have a lot of paintings that I do on paper, on scrap wood that I leave around the city, and I post on my social media, and I'm like, if you find it, you can keep it. So they thought maybe I had done that with some shirts across the country and kind of put it across like across the U.S. and did like a mega scavenger hunt, but I didn't do that. And then once I got home and calmed down, and like I put it on social media, and like I got so many hits and so many people reaching out. I guess one of the good things that came out of it was I formed connections with a lot of other artists that went through this because they all reached out and they're like, we're in the middle of this fight too. Like, it's just upsetting how they do that. So, looking at the pictures again, and then we noticed it wasn't just dicks. It was on the upper right-hand corner. It said Reebok on it. So Reebok stole the whole campaign, and they had a few runners with "Love More Than Ever" shirts on too that they sponsored. So I went deeper, and then like Adidas owns Reeboks, and then there was a couple of local firms that reached out, and then there was a friend of mine that kind of used it for. I don't know if you guys know the Blind Rhino, which is local around here at a bar. So they were in a fight for their logo when they first opened, and then they had this attorney that knew another attorney that represented a lot of musicians. So they represented Wu-Tang Clan and a lot of artists with their mark, with their iconic marks. So I reached out to them. We had a meeting, and it was just like I can't. I don't have Reebok money to fight them because they were like, we want 20 grand up front. And then, from there, we'll take care of this, we'll take care of that, and then maybe 10 grand here. And I was like, what? I don't have like pockets to fight Reebok, so then I went with two local firms that kind of did the 1/3 split, and then we fought them. Happy to say I maintained the rights, but it was unsatisfactory because the day of the opening of like talks that we were supposed to have was like COVID hit, and from there on out, everything had to be through Zoom. And it was like I was sent links here and there, but my lawyers dealt with it. Like they didn't see me. And I know over and over again, they kept telling me emotions have no place in the courtroom. No matter what happens, you can say that, right? No matter what happens, it's like you have to leave emotions out, and that's what sucks. So I wanted them to see my face, and I wanted to dig into them, and be like, how could you do this? And again, had it been maybe some scratch that I did on a piece of paper ended up somewhere, I probably wouldn't have fought as hard. But the fact that I was so passionate about Love More Than Ever, and it was a whole campaign and a whole movement is what stuck out to me. And I was like, I have to fight for this because I almost let it go because it was just they drag you on, and it's like it was 2 years, 3 years going into it. We just settled a year ago, and I maintained the rights, but it was just like it just became anticlimactic because I couldn't. And then at the end they tell you can't talk about it. So it's like you wanted to continue to drag them, but you can't talk about it. So yeah, what I did learn was like, a lot of just there's a lot of layers to it, especially when it comes to street art and graffiti, because I learned like, and you might know the exact numbers, but it's like if a photographer, because it was almost the same thing where on Redbubble and on all this Threadless, like I started seeing my images of Love More Than Ever pop up from murals that I did. But it's like the photographer was getting the money because they did it, and then they printed it on mugs, and they printed because it was their photo. But if it's more than 50% of the photo, or there's a percentage that you have to give up, and then it becomes their property, even though it's your mural, and that's where it gets all complicated and heavy, and you just want to be like, I can't deal with this right now. But it's like that's where they wear you down because it's like your murals out there, and you're like, oh. And then I saw this recently, like a week ago, where it's like there's a guy selling prints of one of my murals. I did the big love mural in Norwalk, and like they're selling T-shirts and everything, and it's his photography and like prints of it. And I'm like, I wouldn't even sell it for half of what he's selling it for. But it's the same thing. Like it's hard to see and hard to watch. And then I just recently, like I started doing like I have like an air pen that I worked on with some manufacturers is getting a patent for that, and that's a whole different thing where I'm developing like this color system that I'm trying to develop. So I had a woman that's an attorney, a patent attorney, came out, and she was like, "You can do a temporary patent for a year, but then you have to show that you're working towards a final patent." But old school way, I dealt with music and I was a DJ, and so what we used to do back in the day was we would do like a demo tape and mail it to ourselves, and then I never knew that that was actual, like that would stick. And she said, take pictures and draw sketches and then mail it to yourself. That way you protect yourself too, on a patent level. But it's tough. It's tough.
Greg knows the answer to that.
I'm not sure. I'm not a patent attorney, so I'm not sure.
Great. So this is fascinating to me for a few reasons. One, because I'm really interested in how social media and the internet is now kind of upending some of the security and safety for artists. And I think both of you are touching on that. So Greg, can maybe you talk a little bit about what are the most common ways that artists have their work being copied, and maybe provide an overlay even with social media if that is influencing?
Yeah, I mean, the answer to that is internet. It's the internet. I mean, I'm going to answer the question and sort of talk a little bit, but I want to do a little table setting first, which is that the internet makes copyright infringement incredibly easy. 100% of the clients who come to me with copyright infringement issues, someone found their stuff online and took it. And in the old days, up until maybe about 5 years ago, I thought maybe there's an argument to be made that people are taking work in a negligent fashion, which is to say they're not thinking about the repercussions, the copyright piece of it. And I'm not really there anymore emotionally. I think most internet copyright infringement is, if not purposeful, then at least reckless. Everyone has heard of the term copyright, and I think it's worth pointing out that the copyright law was originally written in 1976. It was passed in 1976 by Congress. It has not been meaningfully updated since the 1990s, the early 1990s, which means that and the same thing goes for the trademark law, by the way, the Lanham Act, which means that the last time these laws were reconsidered and reconsidered by Congress was before the internet really existed as a fixture in most people's lives. And I want to make sure that you all understand, I'm not sitting here, I'm not going to give you the trick to avoiding copyright infringement or to solving copyright infringement, because the law does not have mechanisms right now to do that. And I'm sitting here and listening to Susan talk about an unsatisfactory resolution, and Five is saying the same thing about how it's an anticlimactic resolution to their issues. And almost every single copyright infringement scenario that I encounter in my law practice the best ones are the ones that have a resolution. And there may not be a financial piece to that. It may just be someone saying, oops, I screwed up, I won't use your work anymore, and they take it down or they do something else. And that's not a very satisfactory way to resolve these issues, but that's what we have to work with. Copyright is a federal law, which means if you want to pursue a copyright infringement claim, you have to do it in federal court. And anyone who's ever litigated, who's ever been to court, knows how time-consuming it is, how expensive it is. And with copyright, there's the added piece that in order to sue someone for copyright infringement in federal court, you have to register your copyright with the Copyright Office. And that's a threshold issue. If you tried to enter court on a copyright infringement lawsuit without having gotten the registration, you're going to get kicked out. Your lawsuit's not going to go anywhere. In fact, the attorney you hired to get you into court, you should probably sue him for malpractice for filing the infringement claim before you even got the registration. And getting a registration is not hard. It's about $45. You can do it online. It takes a couple months for the registration to go through, assuming it's not infringing another registration. But that's a process, and it's a barrier to fighting for your rights and enforcing the law. And one thing you might hear from me throughout the rest of this evening is that there is a distinction between knowing your rights and being able to enforce your rights. And when clients come to me, whenever a client comes to me, it's always they're always in a heightened emotional state. So their work has been stolen. I mean, that's what copyright infringement is. It's a nice way of saying theft. They stole my work. They reused my work. They're trying to make money off of me and my hard work. So they're often emotional. And Five, you were talking about how emotion has no place in court. And that one of the very first things I tell clients is you have to, try to do your best to not panic and put the emotional piece of this out of your mind, because if there's a resolution, it's months down the road. And there may not be a resolution. And oftentimes clients will come to me and they'll say, you know what, I've thought about it, and I'm not going to pursue it because it takes up too much mental real estate. It might be too expensive. It might be too time consuming. I have clients who have, little kids and multiple jobs, and they don't have the time or the effort to put into pursuing a copyright infringement, especially if the potential payout is going to be a couple $100. They're going to spend more to hire me than they're going to get on the back end. So there's no one good thing. There's no one trick to solving these issues. And the internet just makes it harder because you are going to get your work infringed. I'm actually curious, has anyone, I'd like to see show of hands, has anyone had their work infringed that they know of? Okay, so a couple people. I always say this to break the ice with clients. If you've had your work infringed, if you're coming to me because your work has been infringed, that's a rite of passage. You've made it. And sometimes they laugh, and sometimes they're not amused by it. It's increasingly true because of the nature of the internet and how infringement works nowadays.
Yeah, I think there too that there's like this really emotional human response where you want to face the person who stole from you and have them admit they did something wrong and apologize, or at least admit it so that you have like that closure. Like Five didn't get it because it was Zoom and because, all the things, but it's like, you did me wrong, you have to admit it. Only gonna feel better if that happens. I love that. So now that we're all discouraged, it's okay. So Greg, what do you recommend if you discover that your work is being copied? Like you're Susan and somebody just called you and said, hey, did you know your work was on Amazon? What is the very first thing that you should do?
At the risk of reiterating myself, the first thing you shouldn't do is panic and make a decision based from an emotional state. Don't call them angry. Don't send them a nasty email. Talk to an attorney if you feel like you can do that financially, but wait a couple days. Like, you have to let the emotion purge out of your system, because when you do that, and I've seen this firsthand when clients are making emotional decisions, it always backfires. Every single time it will backfire. And you will put yourself, even if you're not going to end up going to court and litigating the issue, you have to put yourself in the mind frame of almost like an investigator. You are gathering evidence. You are pulling together documents. You are pulling together a chain of evidence to support your argument, so that when the attorney sends what's probably going to be a cease and desist letter, and the cease and desist letter may include a demand for financial compensation, that the attorney has stuff that he or she can put into the letter to respond to that. There are things you can do yourself. You can, if the infringement is online, which is to say that you put work up on your Instagram page and then you see it showing up on another website, you can send what's called a DMCA takedown letter. The DMCA stands for the Digital Millennium Copyright Act. It was a law passed in 1996, and it allows you to petition the ISP, the internet service provider, to take it down. So you see this a lot on YouTube or Google, where like if someone reposts a video that they did not make and puts it on YouTube, you can send the letter directly to YouTube, and they will take it down themselves. So it's essentially a cease and desist letter that bypasses the infringer and goes to the ISP. And I actually had a client about a year or two ago where something like that was happening. It was actually on, I don't remember what the website was, but it was YouTube, actually. It was YouTube. And someone had taken his videos, essentially scrubbed his name from them, repurposed them, put them on his channel. And YouTube didn't just take down the videos. They took down the guy's whole channel. And then the guy had the temerity to email my client and say, hey, can you ask Google to put my channel back up? So it wasn't entirely clear if the infringement in that particular instance was knowledgeable. Like, he might have just been an idiot. So there are things you can do, but you can always try to negotiate. You can, and this has happened a couple times with clients who didn't want to go the whole litigation route. I have one client who found out, he's like an illustrator for books. He does book covers, and he found out that someone had taken a book cover illustration that he had done. It was sort of like a failed, not a failed, like an unused iteration of a book cover he had done for a client, and he posted it on his Instagram. This guy found it and used it for his own ebook. And so my client reached out to him directly and said, hey, that's my work. You're using it without my permission. I'm happy to let you keep using it, but you have to pay me $500. And they worked it out. So you can always do that. And you can always go the full route. And if you can hire an attorney and you can file a cease and desist, and if that doesn't work, you can sue them in federal court. But those are really the only options. You work it out, you ignore it, work it out, send a cease and desist, send a DMCA takedown letter if it's an ISP that's hosting the infringing work, or you sue them. And those are the options. And it's, or well, actually, that's not true. There's one more option, and it's a little bit more risky, but you can always call them out online. And the reason it's risky is you have to be careful about what you say, because you don't want to be in a position where you are defaming the person, and you don't want to be in a position where they're suing you for defamation when they've stolen your work. I have seen that, not in my personal practice, but I've seen it in a friend's practice. So you just have to be careful what you're saying. So essentially, you go online and you say, "Hey, Reebok, you're using my work, and you never paid me for it." Any platform you have. Yeah, if you have Facebook, Instagram, TikTok, Twitter, whatever, you can use whatever platforms you have. I mean, it can be risky, and it may not be super useful if you don't have a lot of followers. I mean, I've seen situations where and you see stories like this all the time where someone calls out Delta on Twitter because they had a terrible experience, and Delta immediately rectifies it because, Delta's got a big, it's got a big online presence, or the person who's complaining about it has a big online presence. But if you have 20 Twitter followers and 100 Instagram followers, you may not be as successful going that route.
But also, they try to turn that out on me, because I did do like a whole campaign initially, because they encourage that. My attorneys are like, just go. You have a lot of followers, so just go after them on social media. But then when they were deliberating and bringing everything in, they were like, well, he has enough followers that he'll be okay financially. If just off of the local coverage that I received, they thought maybe they were like, he'll be fine because now everyone's supporting him, so he'll be fine. So that kind of they try to backfire that on me.
That stinks. So I know that Urban Outfitters is really well known for hiring companies that source designs for them. So they're not sourcing them directly; they source through a third party or third parties, where their third parties are like looking on Etsy for ideas. And so in my circles in Instagram and my friends and people I follow, I am constantly seeing like side-by-side photographs of, the original product that somebody made and then the product that's being sold on Etsy and how close they are. I mean, not on Etsy, on Urban Outfitters, and how close they are. And that is typically the way that people work it, is that they ask their entire community and then spread the word and try to embarrass them into taking it down and paying them some money. So it's hard. It was really hard. So let's see. Just make sure. I want to make sure I'm not missing anything here. So for Greg, how often do artists actually prevail when they're defending their copyright? So if they're going to court, for example, is there a small percentage, a large percentage, no percentage of people that actually prevail? Like, how worth it is it to an artist to actually go through with it?
I don't have facts and figures, so I couldn't tell you. But I would actually tell you that the two stories I heard here from Susan and Five is that those are successes to me, because they had a resolution in their favor. They don't really look like successes, and they don't really sound like successes, and neither of you seem all that happy with the way they resolved. But that is a success. If we're talking purely about like litigating all the way to federal court, most cases don't go to trial, and most cases that do go to trial don't actually end up in a verdict. There's usually a settlement. In fact, one of my core memories from law school, I was interning for a small civil litigation firm, and we were 2 weeks into trial, and most judges, by the way, are just cranky old men who don't want to be there. And this guy was a classic, I don't want to be here. And after 2 weeks of the two sides sniping at each other, in front of a jury, he said, go into the back room and don't come out until you have a deal. And that's what they did. So the trial ended that day. So even the cases that actually go to trial will often end up resolving mid-trial because a verdict is a public finding, and many sides don't want that, don't want like a record of that. And the cases, the copyright cases that actually go to court tend to be, big cases where both sides are have a lot of money or something else at stake. And so, I think, not to sound immodest, but every client I've helped, I feel like has had a success. They just look like small successes, or kind of like some form of like coming to acceptance of the situation and growing as people and moving on with their lives, rather than having some kind of actual like copyright resolution. But I consider that a success because you can't avoid copyright infringement today. It's going to happen one way or the other. So.
I have a question for you.
Oh, sure.
Hold up.
I think I had said I resolved it in that my work was taken down, but I never got any financial, never got any money. So someone told me that the major firms like Amazon and Wayfair and Walmart and all those other websites it was on don't really want to get involved with copyright infringement issues and be selling work they shouldn't be selling. And somebody said, if I want to get the sales figures, I should go directly to them. I have all the SKUs, I have all the numbers, I have the item numbers of what was sold. Couldn't they give me the figures? And then I go around it that way, the way you said you could go to YouTube and they would take it down. Would the major retailers not want to get involved with this copyright issue?
So,
It's a good question.
the answer to that question is sure. You could ask them. I don't know if they would give that information to you. When you're saying they don't want to get involved in copyright infringement, what I think that actually means in reality is that they don't want to be sued for copyright infringement, which means that there is a whole sort of understructure of legal contracts between Amazon and its sellers. And if you read any, if you go to Amazon's terms of service for like resellers or whatever, it's a contract from hell. I mean, if you actually print it out, it's probably like 50 pages. And do you want to sit and read that? No, nobody does. So I don't even want to do it, and I get paid to do it. So, and within that, there's going to be a lot of language that absolves them of liability if it turns out that somebody is using work that infringes the artwork of another. There's going to be all sorts of indemnification language that makes sure that the seller who's actually selling the item is going to reimburse Amazon for any legal costs associated with defending from a lawsuit, or even holding a defense themselves. There's something called an indemnity clause, and it'll often say something like, so-and-so will defend, hold harmless, and indemnify Amazon. And that means that Amazon can force them to pay for the legal costs for associating with them, for infringing, sending them infringing work and lying about it, essentially. So it's, you can't, I mean, the reality is most people can't win against Amazon or the big companies. They have, whether or not you're right, doesn't matter. I mean, they have, yeah. Yeah. You can, like I said, you can do that. I have no idea if they'd be willing to. And
Because they're essentially like it's a third-person marketplace. It just is they're just the transaction.
That's right, yeah.
Part. So
Yeah, I mean, they might be willing to.
The thing to do is when I looked into my issues, because Amazon sells a lot of stuff too, a lot of it, once it's international, forget it.
Oh yeah, forget it.
Just don't even look at it. But if it's national, you can track somebody and then you go direct to but you found the source.
Yeah.
Right, oh, yeah.
I don't think they'd share. They might have privacy stuff. They don't want to share data.
Yeah. I mean, they're more likely to just ignore the request altogether than even respond. Yeah, that's the other piece of it, yeah.
And just to go back to it real quick, like financially, I was successful. You have a number. Do they hit it? Do they not? I mean, they hit it to the point where it was successful, but at the same time, I think mine, to go back to the emotion, was that, as a human being, you just want to make them pay. see your face, kind of cuss them out and tell them off. So I didn't get that, so that's why. And then having to sign an NDA or sign an agreement to say you never talk about this again was like I was selling my soul over to them because I was like, now I can't say what I want to say, even though it's past, you know. So that's where I have to bite my tongue all the time and just be like, so yes, it was successful in that manner, but emotionally it wasn't. So that's why.
I think you're saying something that's so key because as an artist, we create because we have something to say. And so that NDA piece is so crushing because you're being silenced and you can't express even from the form of expression that initiated. So that's very complicated. But to circle back to both of you, Five and Susan, I'm wondering if you can talk a little bit about the timeline from the first moment that you realized your work was copied to the point of resolution. So for those of us that have experienced some copyright infringement, what does a timeline look like in terms of pursuing litigation?
Well, in my case, it was fairly quick because luckily, right after I had found all my work out there, I got a newsletter from David Green, who told about a new collaboration that you guys have with that firm in Boston that puts us with lawyers. So just when I was thinking, oh my God, what do I do? That kind of dropped into my lap happily, and I got in touch with them like within a month. And they found me a lawyer within about another month because they rely on voluntary pro bono people, and then they try to connect artists with them. So it's a great organization that, you know, that was very helpful. So in my case, after I found out, and by the time we actually got it taken down, was probably about under 6 months, like maybe four months. So the lawyer was great. He got right on it, and we agreed on the cease and desist letter, and we sent them all out, or he sent them all out. And the person who had been posting all my work probably realized fairly quickly that he was making a mistake and doing an unauthorized sale. And so he reacted quickly, not so much with the money, but he took them down within a month. Yeah, so that was good.
Yeah, I mean, same. Like I kind of talked on it, touched on it. So when I found out, I initially just went just crazy on the internet, on social media, and I just kind of put them out there. And being an artist, like I immediately created like some digital pieces, like David and Goliath images of me going against Reebok. And my attorney was encouraging it. It was like, just get as many eyes as you can on it. You have a good online presence, so get the people behind you. So that's what I was doing. Then like the local media came out, interviewed me a few times, so that kind of helped too to get things going. And then you're kind of stagnant because right as the paperwork and you want everything resolved right then and there, and because mine was like wasn't like a particular person that we didn't know who to reach. They didn't know so they had to do some digging because they found out it was through Dick's, but it had the Reebok logo on. But it could have been through Adidas. So it was like all this investigation stuff that had to happen for them to find out, and so it was just a waiting game, and it's me constantly emailing them like, "What's going on? It's been a week, like I haven't heard anything," and you probably get this a lot, and it's just like we have to file for discovery, you have to file for, and I learned all this legal mumbo jumbo just going through the case, and that was 2019 where it started, and then like I said, COVID hit, so a lot of it stalled out even more so. So then it wasn't settled till late 2022. So, it's a battle that you have to fight, and it's just like I haven't heard anything in like 2 months. And then not only that, having the media because it's all legal, it's all public. So you can go on websites and track a case as to what steps, where it is. So I didn't know because even if I was in contact with my attorney, I would know because like someone would post it or because it's all public knowledge. So as cases as they progress, you can see them in real time as to what stage they're in. So it's like, you know, the paperwork for this is here, paperwork for this is here, and you know, and all of it had my government name, and I'm like, and it's like everything's out there, but then step by step, and then you just see it unfold, and then it it was in the paper before the lawyer even called me. The paper knew what had happened to resolve the case, and I was like, I called him, and I was like, what happened? So by that point, it was settled, and you know, happened. Whatever happened happened.
Okay, so you're not going to be able to give us a specific number, Greg. But in general, ballpark, just so that people are prepared, if an artist decides to hire a lawyer to represent them, what would they expect to pay? I mean, is it $1,000? Is it $100,000? You know, what are we looking at pocket-wise?
Yeah, I mean that's a hard question to answer because that, you know, every case is its own thing. You know, what I can tell you is that most attorneys charge hourly rates, and usually the way that works out is they'll charge you for like a couple $1,000s up front. It's called a retainer fee, and then once they've eaten into all of that, they'll either send you a bill for another retainer, or they will start billing you on the hourly rate on a monthly basis. If you're going into court, or if there's a chance that you might get some sort of good settlement, a sly attorney might charge you on a contingency basis, so they'll take a certain percentage of whatever your winnings are. Some attorneys, like myself, we charge flat rates, and so it really depends on the situation and how you want to resolve it. Clients will come to me and they'll say, "Hey, this is what happened. Can you send a cease and desist?" And I'll charge them a couple $100 for that, and then I'll charge them based on every follow up they want me to do. These things can get very expensive. I'm actually curious to hear from both of you about what you ended up, I mean, if you're willing to divulge the information, how much you ended up paying, because, you've had different resolutions. Yours, Susan, was, I think, sort of like for lack of a better word, a best case scenario, because you had, you got an attorney through VLA, which, means that if you were paying a lower rate, because they're either doing representing you pro bono, or they're taking a smaller rate, and you got a very quick resolution. And conversely, you went through the whole system, and you've been doing it for years. And so I am actually curious to hear how it worked out financially. Not what your resolution was, but how.
It's standard on mine.
Okay, a third. Okay, yeah. So that's pretty standard. Yeah. Yeah, it can get very expensive, and as Five was talking about, it takes years. I mean, even if COVID hadn't hit, it still would have taken years, because once you get into the judicial system, and actually this is a point I wanted to make earlier. You have to think of the judicial system sort of like the medical system. If anyone here has had like a long-term chronic illness or has had a loved one, you get a bad diagnosis, and your initial instinct is, we got to get this treated now. If you get a cancer diagnosis, you don't want to wait 3 months before you start chemo. You want to start today. The legal system the judicial system in particular, works a lot like that. You can't just sue someone tomorrow. There are steps that any attorney would talk you through, that we have to do this, we have to file a cease and desist, we have to make a certain number of good faith attempts to resolve this before we file a brief in court. And once we do that, then it's going to be X number of months before we get in front of a judge for a preliminary hearing, and then X more months after that before we get to the summary judgment phase, and then we start discovery, and that can take, depending on the case, years. I mean, there are some copyright cases that spend years and years and years in discovery before they ever sit for a trial and pull a jury. And so these things take a long time and can be very expensive, or they can be resolved quickly and cheaply.
I see your question. I wonder if I could ask, sorry, I missed earlier, is there some kind of decision tree that an artist could go through? I mean, how do you decide to do something about this, or should I just leave it? I mean, what are the decision points?
This is something I'd love to hear from Susan and Five, but I'll tell you what I tell my clients, which is, will resolution of this make you whole and make you happy? And that's like a question that sometimes they have to sit with. That's not a question they can necessarily answer on the phone with me. And in these situations, my job is often as much a therapist as it is an attorney, because I have to sort of hear what they really want, because sometimes what they want is something that they'll never get. Sometimes they want revenge. Sometimes sometimes they want to hurt the party that stole their work. And no amount of resolution, yeah. I wasn't looking in your direction. No amount of resolution will get that for them, and through the legal system. They'll never get revenge. Even if they get $1 million, they're not going to get revenge. Sometimes all they want is an apology. And you know what? They're probably not going to get that either. They're more likely to get money than an apology. And so I have to suss out what the client really wants and then talk them through the steps to get that if possible.
I think what I wanted more than anything was just to get my work taken down from those websites where I didn't feel that I was, well, I don't want to be selling cheap prints online. I'd like to think I'm a fine artist, and I'm happy to sell prints my way and for my prices and in my markets and in outlets that I feel are fitting for what I do. And I don't want them on Walmart for $46. It was embarrassing to me. When I saw them, I was horrified and embarrassed. And for my friends and clients and collectors to see my work online at those prices in those big box outlets was horrifying to me. And I just wanted him to take it down, and I just didn't want that to be happening anymore. And I'm sorry that the financial part wasn't resolved, but for me, the most important thing was just, take my work down. You have no right to put it there, and I don't want it there. So that was good.
Yeah. And for me, it was similar. Like we did assist and decease, desist, to a point where it took like a month for them to get off the website, and it was just like refresh, call the lawyer, like it's still there. They said they'll take it down, refresh, but because it's Dick's through through Reebok, through Adidas, it's like who's gonna take it? It's almost like too small for them to deal with, because it's like, oh, take these shirts down, or like in the grand scheme of things, it's like we just gotta take those shirts down, and it's like some poor intern probably had to do it at some point, but I wanted them down. Once they came down, then they popped up on eBay, and then they popped up, and then it's like I just want to sue everybody now, because you just want to fight for your art, and then it started popping up, and then because I was in that fight, I had, God bless them, I have friends and family that are on social media that follow me that started adding to the anxiety and the stress, because they're like, oh, there's this one-off seller on Etsy selling prints with your words on it, and I'm just like, I can't go after everyone. Like at some point, it's like you just gotta laugh at it, and it just be like, it is what it is at some point. But I would just say if it's more so like a photographer, like mine's on Shutterstock sometimes, and if it's a photographer or another artist that's using it, like it's like hey, like just give me credit, just give me credit. But if it's like a Walmart or like a Amazon, like I'm like, take that shit down. Sorry, take it down. Like I don't want it up there, because I don't want like the corporate world to have it and just use it. So I guess I have to agree with Susan. The biggest thing was just take it down. Once it's down, you kind of feel good, but it still hurts. We're artists. Yeah, yeah.
So Five and Susan, do you do anything different now when you put your art out into the world? Do you do a dance? Do you do you label it differently? Do you think about it a really long time before you put it out? Like, are there steps that you feel that you take to protect yourself? Do you kind of just let it go and let it be?
In my case, it wasn't stolen off of Facebook or Instagram. It was actually somebody I had done business with who had access to all my files. So I wouldn't let that happen again.
That's very rare, by the way, because what he did is what most infringers don't do, which is he credited you. He was trying to profit.
He used my name, he used everything,
Yeah, he was trying to essentially make himself look like a broker for you.
Exactly.
And that's not common. Most infringers try to scrub your name and try to take credit for the work for themselves.
Oh.
So it's a very unique situation.
Seems like they made it easy for the lawyer in that situation.
Yes, I mean, he knew he had to take it down. It was so clear. Hello,
Easy
right,
to have a lawsuit.
Day?
What about digital watermarks? Do they do anything?
It's a good question.
I mean, I guess, yeah, but it depends on where you put it, I guess. Because for me, it's like I could put it, you'd have to put it in the center of the piece, and just from a graphic standpoint, like
It's very hard.
it's more protective, yeah. And what all the attorneys that I dealt with told me that, like two of them told me, if you have an idea, you draw it on a napkin, it's your idea, regardless. You could take a picture of it, it's your idea. So if you put it on social media, it's still your idea. If you can prove it that it's on social media, so social media is good and bad, because if it's on social media before a date, because during discovery, they track back to like, at the time it was 2020, 2021, all the way back to 2017, 2016, when I first posted my first Love More Than Ever thing in Chicago, and like they had to track it back, screenshot it just for proof that I came up with this back then. So it's tough because, like, and then again, I guess it depends on the artist, right? Where I do the scavenger hunts, street art is different, as opposed to fine art, where you have more control of that. Where street art, anyone can take pictures of it. Excuse me, and then I do those art scavenger hunts where I give away a lot of free art. So you never know who's gonna pick it up. It could be an addict, someone that picks it up and reuses it. And I think for me, more importantly, it's just credit. Just give me credit. Like I don't need, I don't need to sue every single person, because it gets expensive for every single painting or every little like tagline I come up with to try to copyright it. It costs money, and then just to try to copyright everything, it gets, because Love More Than Ever, it lends itself to a lot of things where now people are reaching out to me, and it's like, can we put pizza there, like Pizza More Than Ever? Can we put, like hats more than ever? Can we change it around and say something else, but it's still yours? Can we license it? And then you're just like, no, I don't want pizza more than ever. Like I love pizza, but I don't want it to be, yeah. And they're like, oh, we could put, a pizza pie and use it. And I'm just like, I don't know. Like right now, there's, just other people that have last names Love, and like, can we use that as a? I'm just like, it becomes too much sometimes. You just have to laugh at it, but.
Can I ask a question, like for in Five's example, like is there a way for him to reverse, sort of put a contract out there that if anybody photographs, takes his stuff, reposts it, whatever, and asks that if they participate in that sharing, that they give a credit to sort of, I mean, I don't know exactly how you would do that, but sort of put that out?
Yeah, sort of like a Creative Commons sort of post hoc thing. Yeah, for sure. But I mean, anyone. Okay, how do I put this? Anyone who wants to infringe your work, that is, take your work and profit off of it in some way, it's going to happen. I mean, as bleak as that sounds, that is the system we have. The legal system is not set up for the volume of artwork that is out there and the volume of work that people produce every day. When the Copyright Act was written in 1976, America had like 100 million people, and now we have 3 times that many, and all of them are artists. we're all just posting our way through it, on Instagram and TikTok, and so in a very real sense, there's nothing that can be done to prevent copyright infringement of your work. There are strategies you can employ. So you mentioned, watermarking your work. You can absolutely do that. I am concerned about the proliferation of AI apps that can essentially erase a watermark while keeping the integrity of the work. Yeah.
What's copyright for AI generated stuff?
I'm sorry.
What's the copyright on something that's AI generated?
It's the yeah. There's no wise old guru. There's no settled law. There was a recent federal court decision that said that artwork generated by by AI software does not have copyright protection because copyright is designed to benefit human created artwork. That's one decision by a federal district court judge in Washington D.C.
There's a suit right now about, from a lot of writers, right? That their information was pulled on the internet and generated from the input into AI, so there's a lawsuit.
Well, but there's a lawsuit right now. It's open. It's an open question. You know, I have no idea. I have, certain predictions about what I think is going to happen. What I think is likely to happen is that some AI generated stuff will be considered copyright protectable and some won't. And it's going to be a very messy next 25 years. But, putting aside the AI copyright piece of it, any reasonably skilled app developer can write an app that will erase watermarks, that can take low-res images and turn it into a high-res image. Because up until about 8 months ago, I would give a presentation about how to protect your work when it's stolen online, and about half of it is obsolete now. I can't give that presentation anymore because AI, forget it. It's the technology is advancing. Like I said, the law was written 50 years ago, and the technology is advancing decades in months. And so, who's to say how it's all going to play out? All I can say is, you have to. This is going to turn into a bit of like a kumbaya thing, but you have to make a certain amount of peace with that. This is the world we live in. There's no amount of law that can protect you from it happening again. Any resolution you have on any particular copyright issue you have today does not insulate you from having a copyright issue tomorrow. And coming to terms with you and yourself about what is worth fighting for and what is not worth fighting for. Just a brief aside, I have one of my freshman year college roommate is a very talented and very well-known designer and artist. And about 7 or 8 years ago, he had been hired by he's a graphic designer, and he had been hired by a big company, to do design work on a piece of software, and the software itself had some trade secret, code that was highly protected. The company, it was proprietary. They didn't want it getting out. It was protected by trade secret. But one of the developers on the team was secretly a mole for a rival company. So it was like classic corporate espionage stuff. And he took the code to a rival company, and the company my friend was working for sued the other company. But my friend, the designer, who never saw the code, was not involved in the writing of the code, it was all design related stuff, he got sued as a defendant. He was brought in he was impled as a third party defendant, which means he had to hire an attorney, he had to defend himself. And he called me, he's like, "What do I do?" And I said, "Well, the first thing you do is hire an attorney to represent you." This is in Florida, so I wasn't able to defend him. But I said, the next thing you need to do is come to peace with the fact that this is going to be the next 2 years of your life. You need to build it into your life. You need to find the emotional space for it. If you don't do yoga, start doing yoga. If you don't meditate, start meditating. And find a way to pay for this. And I told him what's going to happen. What's going to happen is 2 years from now, the judge in particular, will realize that you're not actually a party to this, and will dismiss the suit against you. And then you're going to have to sue the defendant to recoup your legal costs. And that's exactly what happened. But he had to find a space for it in his life because it was 2 years of his life.
I actually know of a case of a friend of mine who is well known in the field that I work in, which is quilting and art quilting. And the largest quilting conference that's held in the world, or in the United States, is in Houston every year. And it's held at the Giant Convention Center, it's the biggest convention they have every year, bigger than football, bigger than everything. 55,000 people go to this every year. And attached to the convention center is a Hilton hotel that was being remodeled. And we all went one year. I used to go and teach there. and the carpets in the entire hotel were done with a design that was very obviously a motif by this particular quilt artist. And we all looked at it and said, wow, this is great. This is so good for her. I'm so happy that, she made this deal. This is so cool that her carpet is, or her design is on this carpet everywhere. And then she got there and said, holy cow, I did not give permission for this to happen. And so it was years, and those of us who know her and are familiar with her work had to give statements to her lawyer saying that that was our first thought. We immediately thought that was her design. It was on hundreds of thousands of yards of carpet. All through the hotel, every public space in the hotel, every hallway, every restaurant, everything. She had to sue the hotel, the designer, the carpet manufacturer, the carpet installers, pretty much everybody, just to basically be covered. And it took years for it to be resolved. And as far as I know, because there was an NDA involved, she had a very substantial financial settlement because she did not force them to remove the carpet. It would have been within her rights to ask for that to happen, like asking for your work to be taken down, but decided that cash was probably the way to go at this point because her work is now seen by every single person that goes to this very large hotel. And if you're financially compensated for it, I think that's probably a good resolution at that point, even though you might want revenge. So to that point, Five and Susan, do you do anything differently now? Oh no, I asked you that question already, sorry. Do you find yourself sharing less art than you did before? Just because you're thinking about it? Is it in your head oh boy, I'm worried about this being, stolen or not? So do you share less work in the public than you did before? Has anything changed?
For me, no, because I'm cockeyed optimist, and I feel that this was a bad guy who did this to me, and I don't think generally if I post something online, it's going to be stolen. No, I don't. Maybe I should, but I don't. I can't live that way. So.
Same. I think I post more, but I think I'm more cautious. I'm more cautious of what I post. I guess I reach out to my attorneys. I'm like, is this cool? Like, I had a company approach me maybe like a year and a half, 2 years ago almost, about NFTs, which was another big thing that just fell off the map. But they wanted me to develop this whole line of NFTs, and one wanted to kind of incorporate Love More Than Ever and create it as an NFT. When I spoke to my attorneys, and again, like the Wild Wild West, they were like, we don't know too much about NFTs. We don't know. So I didn't want to put it out there. I didn't want to put it out there in that space. And as far as AI, I do use AI here and there, but like Greg said, use it as a friend. A lot of the times I prompt it for painting ideas or for visuals, and then I'll get I brainstorm with AI. It's learning, it's scary, it's but you can brainstorm with it, and sometimes you'll get ideas off of that. But NFT itself, I'm very, very wary of that, and it's gone by the wayside now. But so I'm more cautious and conscious of what I post. I just, before I post it, I know that I might, I hit it and I'm like, I might be another lawsuit. I don't know. Just because you don't know who's going to take it, where it's going to end up. But yeah.
So, Greg, if you were to give us advice about taking actionable steps before we make our work public, what would you suggest that we as artists do?
Okay, there's a couple things. So we touched on watermarking. You can reduce the resolution of your work so that it has less functionability if someone tries to use it and repost it somewhere else. This is not like a posting your work online thing, but one of the things that I think it would be a very helpful practice for artists to get into is making sure that they're getting written contracts with potential clients and customers. I know that was an issue. Susan, you had mentioned you didn't have a written contract, but a good written contract it's not going to prevent someone from going onto your Instagram and pulling work down and reposting it, but it will prevent something like that, where, you know, someone you're working with has, let's be generous, a misunderstanding of what their relationship is with you and with your work. Yeah. So, you know, and it gives you theoretically recourse for when that happens. It gives you something you can point to. Hey, this contract said you are not allowed to do this, this, and this with my work. So, you know, building that into your life and your workflow. Artists always think that the hard part is figuring out the art, but that's the easy part. That's what you're all trained for. The hard part is getting into the mindset and building this ugly, stupid business stuff into your work, into your business, because that's, you know, nine out of every 10 clients that come to me, it's a contract issue. It's not a copyright infringement issue. Or if it's a copyright infringement issue, it's related to an underlying contract issue. So that's one. I'll get to your question in a moment, sir. But, you know, so the contract thing is a big one. You know, Susan and Five mentioned that it hasn't, you know, they're not they haven't, well, I don't want to put words in your mouth, but you're saying that, you know, you're not necessarily changing your habits about what you're posting online, but at least being cognizant of what you are posting online. I mean, if you're a photographer and you're taking hundreds or thousands of photos, don't post them all online. Maybe pick one that represents a series. You know, that's just fewer chances for someone to repurpose your work. If you are doing that, you can file a copyright registration for, especially photography. You can do a batch registration. But if you're a painter, you know, before you post it on Facebook or Instagram or whatever the apps are, Behance, whatever people are using nowadays, file the copyright registration, then put it up. So at least you're starting to build like a safety net for yourself. If you have to pursue someone for copyright infringement, you're having things you can point to. Hey, I have this contract. I have this copyright registration. If you're posting on a website or an Etsy, or there are certain websites where you can add your own terms. You know, this is for informational use only. This is for personal use only. You cannot repurpose this or resell it. So adding in language, restricting what a buyer can do with your work. You know, obviously, some of this stuff may not be applicable to you depending on the art you are engaged in, but but I think being cognizant of and thinking about what you're doing before you do it is always a good first step. I know you had a question. Oh.
My question, I am not an artist, but work with a lot of artists and creatives. And in our current iteration of standard template contract, under the copyright section, we own the artwork that we pay for, but the artist retains the copyright.
Yeah.
Is that fair? Good practice? What's more fair? What's better for artists? Like, is there template language out there as someone commissioning work and paying for it can be more supportive of a good livelihood?
So the answer is it depends. That's a very common refrain in the law. It depends. I'll sort of answer your second question first about template language. There's always language out there. Just be careful about what you use. If you're Googling language for, like, you know, copyright protection stuff, just make sure you understand it before you use it, because I have seen clients use language that they thought was really cool, and it turns out was actually really harmful for them. So just be careful about what you use when you're pulling it from online. Depending on the work you do, yes, it is perfectly fair for the artist to retain the copyright, even if they're selling a physical work. So, you know, there's a painting over there in the corner. You know, that's a great example. There's actually two pieces of ownership that attach to that painting. One is owner of the physical property, and then the underlying design work. And so if I'm the painter and I'm doing that painting for you on commission, you want the physical painting at the end of it, right? But I may not necessarily want you to have the rights to the work. So, because I might want to take that image and put it on T-shirts or make it the logo of my business.
Big issues with museums.
Yeah.
Very often they forget that they may own the work, but they certainly do not own the copyright.
Well, yeah. I mean, it depends on the work too, because some work, if it's old enough, it's in the public domain, and then, but you know, there's.
They can't copyright it because it's out.
That's right. Yeah, and what you see is. You know, corporations like Disney, for example, you know, the copyright law is often sometimes referred to as the Mickey Mouse law, because as a character like Mickey Mouse comes closer to losing his copyright and be moved into the public domain, Disney starts engaging in activity. So they're fighting it on a couple fronts, right? They're lobbying Congress to amend the Copyright Act so that it can extend their copyright ownership. But they're also refiling copyrights or they started a couple years ago doing live action remakes of their famous animated films, mostly as a practice to retain copyrights to older films, to like these stories, so they don't lose Cinderella to the public domain. And it's complicated too by the fact that different countries have different laws. So Sherlock Holmes is in the public domain here in the States, but not in the UK. And so these things get pretty complicated pretty quickly. But short version is yes, it's perfectly fair to retain the ownership, to copyright ownership rights. That may not be the case if you're an employee working for an employer. If you're hired as like a graphic designer, it is understood generally that the employer wants to own the fruits of your labor and will do so. But they'll make it clear in the contract language when they hire you.
So Jane probably knows the answer to this, but we would love to have a volunteer lawyers for the arts in this region. It's sad that we have to go to Massachusetts.
They're trying to build out a Connecticut.
I know.
Piece.
But are there reliable templates for contracts? I should know this. Are there books like?
What resources are available to us?
Okay. What do you use?
What do I use?
Yeah, for contracts.
Don't answer that if you think it's going to incriminate you.
I've signed book contracts in the past, and the first one I ever signed was in 2005, and it was so scary, and it was so long, and I kept trying to negotiate with the publisher for better terms because I wasn't getting in advance, and everything I asked, the answer I got was, "We are not in alignment with that." What does that even mean, right? So that meant no. And so I did end up consulting a lawyer and somebody who was comfortable working with authors and publishers and things like that. And I guess my advice would be that a lawyer would be the way to go. I have written contracts for teaching and things like that, but I'm not as worried. They're like short-term, one-time use only type things. And I've not ever had to sue anybody or been sued by anybody in a circumstance like that. I'm sure the contracts, because they were cobbled together from the internet, are probably not great, but would hope that they would protect me as well as they should. The book one, though, that one was because they drew it up and it was very long, and I used to joke that it was like they own the copyright until 75 years after I died, which is typical, and that they had rights to any known or unknown technology for reproducing the work and any on Earth or anywhere yet not discovered. So like they covered every possible base they possibly could. They actually treated me really well, and I felt like but they really were making sure legally that they were like super duper covered by everything. So I always joke that like I'd be dead and my work would be on Alpha Centauri and it would still be covered by their contract. Yeah, it is. It's definitely true. So finding a lawyer, making friends with people who are married to lawyers or are lawyers is also helpful. Knowing people who are lawyers is helpful. Coming to workshops like this is really helpful because you can ask questions about things like that. I personally feel like contracts are really needed and that we're all kind of stumbling along in the dark unless we have a lawyer helping us with it.
Yeah, let me just say, there's no way to say this without sounding self-serving, but I don't refer people out to online resources like LegalZoom or whatever, which is not to impugn the quality of their contracts. They're just not written for you. They're written for everybody. And I actually think, and this is not like an answer you might want, but I actually think it's safer, legally speaking, for you to write your own contract in your own voice than to use something you found online, because you don't know, all these contracts are written in legalese, and it looks like English, but it's not English. And I over the last almost 12 years now have learned how to read and write it. So I'm fluent in legalese, but most people aren't, and they will often put in language that is irrelevant, is redundant, it doesn't have anything to do with what they're dealing with, actively harms their interest. They're giving away ownership that they don't intend to give away. And so one of the best contracts that I ever saw that I never wrote was from a friend who hired me to review a contract that she had written herself. And I was like, it doesn't look like a contract. It's not written the way I would write a contract, but it did the job. And I was like, I actually thought about refunding some of her money. I didn't. I kept the money, but but I thought about it because I was like, this is really good. And she just decided on her own to write her own contract.
That's really interesting. Is there ever a circumstance where if someone was copying your work, Susan or Five, that you would let it slide? And Greg, is there ever a circumstance where somebody brings a copyright violation to you where you would recommend that they let it slide?
You mean copying it for resale?
Or if you've discovered somebody was copying your work and you were like, you know what, that's okay. Could you imagine a scenario like that?
I don't think so. I mean, if a friend wanted my work, I would give her a print or him. I mean, I can't imagine why anybody would want. No, I don't think I'd be comfortable with that.
I think I mentioned before, I do let some people slide, like photographers, because street art is different. So it's like I've seen them share their photos with my mural in the background. And I mean, again, like you have to pick and choose almost when you get to a certain point and just be like, you can't fight everyone. Like I don't have the time in the day to constantly. And again, like I have family members or friends that are constantly sending me links. They're like, hey, look, this is a little too close to, and I'm like, don't do that to me because it's just like I was gonna stir the pot and I'm gonna want to sue everybody again. But at certain instances, you have to kind of let it slide. And if I see it's like malicious, and I'll reach out, or if I see if it's like a little too close, or if it's exactly the same, like I'll send a note or I'll send it to my attorney, and I say, hey, like this is a little too close. Then they'll send a cease and desist, or I would just approach the person, well, over the keyboard and say, hey, like this is my stuff, and they're like, oh, I'm so sorry, they'll take it down. Or if they I'm like, just give me credit. If you're posting it, don't act like it's yours. And if they're cool with it, then I'm cool with it. And as long as they give me credit or what have you, it depends. Every is a different case. Yeah.
So I personally would never counsel a client to do anything, to let it slide or to sue somebody. My philosophy, and different attorneys do this differently, but my philosophy is the client determines the strategy and I determine the tactics. And so if the client says, I'm going to sue that bastard, I'm going to sue him for every cent he's got, it's my job to figure out how to make that happen. But I do, it definitely depends on the scenario, on the specific instances, and there are situations where I've talked through with clients what they really want and what the likelihood of success is, and in certain instances they say, you know what, forget it. It's not worth my time. It's not worth my effort. I think that both Susan's situation and Five's situation are both situations that I think warranted going all the way and not letting it slide for different reasons. Because Susan, in your case, this is someone with whom you had a business relationship, who again, to be generous, had a distinctly different understanding of what that relationship was than you. But the end result was someone who was, using your work in a way you did not approve of, and was profiting off of it in a way that didn't really make a lot of sense given the kind of artist you are and what your ultimate goals are. And for Five, the situation was big. There was a lot of infringement going on, and at a certain volume, you can't let it slide anymore. You have to fight. whether there's a financial incentive to do so or whether it's personal. But yeah.
This is not a question, but I was going to ask if people were organizing some type of advocacy to update that copyright law, because yes, that needs to happen. Well, because I'm very concerned about AI, so I'm a literary artist, and I think words are even trickier. So I've had people on the internet take phrases from poems and insert it into essays, and you're like, what do I do about that? How do I approach that? And it just becomes unwieldy. Even newspapers using catchphrases that I've written on Twitter, as a headline. And so it's really difficult to figure out as a literary artist how you can kind of pursue litigation. And I think this law is important. So are there artists who are also a part of that effort, or is it strictly corporations? Because I think if it's strictly corporations, there might be some concern there in terms of like how many voices, artistic voices, are represented in the rewrite of that law.
Well, so the first way I'll answer that is anyone who's watched the news over the last 2 days knows we no longer have a Speaker of the House, which means the House of Representatives cannot legislate. And without getting political, Congress right now is not really all that incentivized to do things like amending the Copyright Act, updating the DMCA, updating the Lanham Act. I mean, we're facing another government shutdown in 6 weeks if there's no new Speaker of the House and if Congress doesn't pass appropriations bills. So I don't envision any meaningful amendments to the copyright law to address technology, AI, any of that stuff. The one bright ray of hope is that at least in the Senate there are senators from both sides of the aisle who really, really hate tech companies, like really hate Twitter and they hate Meta, they hate all of these companies, and really want to legislate against them. And I mean, we're seeing the first real antitrust lawsuit in decades happening right now against Amazon, and that's a good sign. It means that if Amazon gets broken up, it'll be harder for Amazon to just sort of, mine you for information and charge you, upcharge you for every time you want to sell something on their platform. So those are good things, and if you can get Josh Hawley and like Chuck Schumer to agree on something, that's a good place to be. What an amended copyright law would look like is really hard to know because, as we mentioned earlier, the technology is evolving so fast. I mean, a year ago, there was no video AI systems, and now there are. And it's become such a worry point that the SAG-AFTRA is striking in part because they don't want to be replaced by AI actors. And the WGA recently got a tentative deal, the Writers Guild recently got a tentative deal which addressed some of these AI concerns. And I don't know, I think like the WGA deal is like a good sort of model for like advocating and working together. The WGA is the benefit that they have that a lot of creative industries don't is that it's not only unionized, but it's a really strong union. Hollywood unions are very, very powerful. And the WGA and SAG are amongst the most powerful unions in the country. So they have some weight they can throw around. It helps when like Brad Pitt and Tom Cruise and Zendaya can like walk the picket lines and advocate for you. And but even if you're ununionized or non-unionized, there are advocacy efforts ongoing, but I think this is going to be a problem for time to come. I do not anticipate any amendment to the Copyright Act in the near future.
I mean, there are grassroots artists unions, and
Yeah.
that might be. I mean, I can't think of any right now, but there are group freelancers using it. But there's a group working on payment. So it's like we need unions. We need an artist union.
I wholly agree.
So you said before, Greg, that there were basically three things that you could do if somebody infringes your copyright. You could sue them, you could ask them to take it down, and you could leave it alone. So I know Julia in the audience had a case, several cases recently where people were infringing her copyright. And can you tell us about the one where you approached them and offered them a deal?
Yes, yes. I know, I was listening to you guys saying you just wanted your stuff down. I wanted to see, and I wanted the pieces that I found from where I found this one specific. I have had a lot of instances of copyright infringement overseas. And this one instance was from a manufacturer overseas that was purchased by a US-based company, a nice-sized US-based company, and was selling the product everywhere. Same format. I think there's a system now where you can like hit one button and it goes out to 20 different retailers like Wayfair, whatever, because it's everywhere out there. So, but they were the manufacturer, and because they were a reputable company and they were operating in Georgia and had been doing so for 30 years, I had a nice conversation with the owner of the company. He gave me a call when I saw what was happening and called them. He explained that, it happens sometimes. Sometimes they purchase from a manufacturer that says they've created the art or they've created the piece, and so, he said, I'm happy to look into it with that manufacturer that we use. Of course, he went back to them, and they claimed that the artist that had created the work was no longer at the company, and they didn't have any documentation to back it up, yada, yada, yada. At that point, I said, well, if you're working with artists and doing things, what's the type of relationship that you have with artists? What's your licensing contract? Because I license my work with other companies. I haven't done so. This was a pillow. I haven't done so in fabrics. It was a different industry for me. So I started a dialogue with him about that. I thought he was lowballing me when he responded back, but I sort of got an admittance from him that he had liability. And from there, I did contact a lawyer, tell them the story, and they advised me a bit differently about that, and we did settle. We came to terms about it. They did pull their reports, so they were a much more reputable company. They shared their reports of their sales, and when there is infringement, your percentage on licensing, isn't like 2%, 3%, 10% what the standard is for art prints. It's damages, it's 25% or 50%. It could be all profit on a product. So the settlement on something like that's a little bit better, because you're recouping basically any profit that they made if they're sharing their numbers.
Right.
So that dialogue with him was beneficial because it got me some information, and I probably would have just done a deal with him directly, but I don't think he was. The deal he offered me was. I figured, let me try with somebody else, and it happened. I did find a lawyer who gave me some information, so I was able to pursue another avenue and sort of do things like that.
That's cool. In my case, they offer that to license. So, like the first attorney I had, he was like, "Are you interested in licensing to Reebok?" And I said no because the T-shirts that they were printed on, the way they did it, I didn't like how they were doing it.
Yeah, and
So
that has a lot to do with it, right?
exactly,
When I saw what they did, it was beautiful. It was a beautiful product.
yeah.
I said I wanted some samples for myself, and I let them keep the remaining inventory and sell it through, and they're paying me royalties off of it.
And then it just wasn't the soul of, because Love More Than Ever was more than just words. It was like a movement, so it was different than just a piece of like artwork for me. And it was just more like they won't understand the movement. Like it's not it's you know what I mean. It's like a, so they didn't get it.
Do we have any questions from the audience?
I had a couple of things I wanted to say. I think it was a blessing in disguise that you had to go deal with your legal battle online, not in person. And then, is that your love mural in East Norwalk?
Yes,
I
it is.
love that mural.
Thank you.
For years.
Yeah.
Okay, I do have a picture of it because I love it, but I never posted
That's
it.
fine. That's fine.
And I just wanted to say, I work for Duracell, the battery company, and a fun fact, the bunny, there was some legal battle that happened, I don't know any of the
details, but basically Energizer and Duracell came to the conclusion that Energizer can use the bunny and Energizer uses the bunny in North America, and Duracell can use it, we're able to use it in the rest of the world.
Wow.
Yeah, because I guess Duracell initially had the bunny, but didn't do any trademark or copyright or anything like that, and then Energizer came out with the bunny. So whatever agreement they came, the final agreement was Energizer North America and Duracell rest of world.
Fun fact.
I want to add something that I didn't mention that we can talk about is, I also held copyright on the piece of artwork. I had registered it. It was the one piece I had registered.
Wow.
And
Nice.
since then, learned that you can register batches of work,
Yep.
as in work in progress, in batches of 10, and just do one fee. So that's also a nice way to do it as well.
But let me just add, I get asked all the time what a common settlement is, and I'll tell clients, there are some really crazy settlements, like agreements, like the Energizer Duracell agreement. That's bonkers. That they share a mascot just in different parts of the world, and I see crazier stuff more often than I see what you'd constitute like a typical agreement. So.
I have a two-part question. One for five. Regarding the Reebok deal, was there any way, if you wanted to turn that into a business relationship where you're designing T-shirts instead of using their design?
I was brought up as part of the as part of the licensing, because then another attorney stepped in and said, "Hey, would you be interested in like building a relationship, maybe working as a design on their team?" But I think I was too far into slamming them and calling them out on social media to be like, "Hey, I'm working with them now." You know what I mean? Like, just because I have a base and like I have people that follow me, I'd be like, oh, you totally sold out, So I think I opened my mouth way too soon because, had I came at it nicer, maybe that could have been a thing, but yeah, I think I was already in too deep. Yeah,
I would want to John Wick them too.
yeah.
So second question is regarding copyrights. What's the difference with copywriting and trademarking? And what type of protections do they have?
Sure. So there is some overlap between copyright and trademark, but copyright at its most basic level is, I think the language is artistic expression any creative work fixed in a tangible medium of expression. So art. So art in any fashion. So music, painting, film, dance, and dance is actually an intriguing one because if you're choreographing a particular dance, the choreography, if it written down, would qualify for copyright protection, but the performance itself would not because it's not fixed in any way. However, if you record their dance, then the recording would carry a copyright. And music often carries multiple copyrights. So lyrics, music, and then the recording itself. Any song you hear through Spotify will carry upwards of 3 or 4 copyrights on the one song. So so it protects art. And the nice thing about copyright, a lot of people will say copyright as like a verb, like I'm going to copyright something. But copyright is not a thing you do. Copyright is a noun. It describes a certain kind of protection that your work gets. I mean, I do it all the time. I say I'm going to copyright this. I'm going to copyright that. It's just a shorthand, but really it means it's referring to the protection that you get under the law for works of art. Trademark protects marks and service marks that are used in commerce. And so logos, business names, product names, slogans, restaurant design, believe it or not, constitutes a trademark. It has to be used in commerce. So if you are just coming up with like a catchphrase that you're using amongst your friends, or even in your own work, but you're not using it as a commercial asset, it would not be a trademark. But if you're using it as a commercial asset, so a trademark is essentially an intangible business asset, like a branding identity that you use for your business, for your products, for your services. The way they overlap is sometimes you hire someone to design a logo for your business or for a product line you're launching, and that logo or that artwork will carry both copyright and trademark protections because it is a work that was designed by an artist or a designer, and goes through the typical copyright process. So.
Could you explain the difference? I mean, every artwork naturally gets copyright, but then you can also register your copyright. Could you explain the difference?
Yeah, so the way the copyright law is written, the moment you put pen to paper, copyright attaches. So you have copyright protection. You own the work the moment you start creating it. Again, when you're recording it in some fashion. So if you're just thinking up an idea for a painting or a film, that doesn't have any protection. But once you put it on paper, once you start recording, once you start drawing, whatever, copyright attaches. You cannot sue for copyright infringement unless you have a registration. So, if you don't register your work, you do a painting and you put it up on Instagram, it's yours. You own the rights to it. You have all the rights under the law to protect it, except you cannot sue if someone tries to infringe it. To sue, you would have to go through the registration process.
And could you talk just quickly about how complicated that is?
It's actually very simple, and it's so simple that I don't do it for clients anymore, because it's not cost effective for anybody. It's a waste of my time and it's a waste of their money, because you go to the Copyright Office, copyright.gov. You go to the portal. It's right on their main page where you fill out a registration certificate. You pay the fee, and the fee varies depending on what the work is, but generally it's $45 per work, and it goes into the system. There's an attorney who works for the Library of Congress, which is the federal agency that houses the Copyright Office, who will review it, and within 3 to 4 months, if everything goes right, you get a registration certificate.
You can do this in batches?
For certain types of works, you can do it in batches. Most recently, the Copyright Office updated your ability. So if you're a photographer, you can batch register multiple works at the same time. So you're not registering each photograph for $45 a piece, because that would get cost prohibitive. Yeah. Copyright. Yeah. Trademarking is a whole. Yeah. No. Trademarking is one mark at a time. Trademarking gets very expensive very quickly, because and the thing about trademarking, and I'm not going to go into a whole long thing about it, but when you're coming up with a mark, whether it's a business name, a slogan, a logo, whatever, you can't just have it for everything. So, again, this is not to get political, but this is a great example. When Donald Trump was hosting The Apprentice, it famously made news that he was going to trademark the term "you're fired." But and then because I remember all the news around it was like, oh my God, that means managers can't fire employees anymore because now they'll be infringing the trademark. But that's not how trademark works. You have to attach your trademark to a class of goods or services.
That's where it gets tricky.
Yeah.
And that becomes the process.
Yeah. So an example I like to give to clients when they ask this question is, if you want to start like an app, like a tractor supply company, and call it McDonald's, you can do that, because nobody's walking into your tractor supply store looking for a hamburger. But if you start a fast food restaurant and call it McDonald's, they're going to sue you because you're creating confusion in the marketplace. And I mean, you wouldn't even get the trademark to begin with, but even if you got lucky enough to sort of slip through the cracks and get the trademark, McDonald's would sue the hell out of you.
I'm an ecological and landscape designer and I lecture. People are always asking me to go on Zoom and put all my images out there and my words, and I say, no, I don't trust it. Mm-hmm. Should I be copywriting my lecture to protect myself?
Probably not, generally, because lecture materials, like certain educational materials, do not qualify for copyright protection. And the reason behind that is that copyright does not protect facts or ideas. It only protects expression. And so if the materials themselves carry a certain amount of artistic originality, then they might qualify for copyright.
What about all these images that I'm projecting?
The images would carry copyright for sure.
Okay.
Yeah, if you own them. If you're pulling them from the internet, then
No.
okay, yeah. Okay, yeah, then those images would absolutely qualify for copyright protection. It's just the like, people ask me all the time about like lecture slides or like educational like pamphlets, and
because I'm so
There's a
afraid
gray
they're gonna
area.
bootleg my lecture.
Yeah. You can actually record the lecture, and then that would qualify for copyright protection.
Well, okay. That's what I'll do.
Yeah.
Actually, I have a technical question. So you said you can't sue for copyright infringement unless you have registered your copyright. Does it matter when you've registered it? So if you discover, like Susan discovered that her work was being infringed, could she have then copyrighted it and then sued the guy? Like, she didn't do it at the time she created the work. She did it right before she filed a lawsuit.
So this question gets, this answer gets a little technical, but you can absolutely register your work with the Copyright Office after you found out you were infringed. The benefit to doing it before, like right away, is you get to sue for what's called statutory damages. And this means that written within the Copyright Act itself, it says you can sue for a certain amount of money when, and you don't have to like go through discovery, you don't have to figure out how much you actually lost because of the infringement. This document, because you registered it right away before it was infringed, it sort of simplifies the whole process for you. If, as Susan, in your situation, if you registered it after you found out you've been infringed, that's fine. It doesn't change anything in terms of your ability to actually sue, but you lose the ability to sue for statutory damages. You now have to sue for what are called actual damages, which means you have to prove how much money you lost, through the infringement. And, sometimes that's pretty easy. I had one client tell me he lost $16 million, and there's no way he lost $16 million, but he claimed he could prove he lost $16 million through an infringement. But for many people, it's actually really hard to show, because you have to show that, I sell my work you actually need a lot of information, right? You need to know how much this infringement, the infringer sold, how many units he sold, how much he sold them for, what his profit margin was, and what yours would have been in a similar situation. And that's not always easy. It's easier sometimes on like the fine arts than it is like with film or, photography or something like that.
Any other questions? Awesome. Well, we really want to thank all of our panelists tonight. I'd like to say that you definitely want to be following Greg on Instagram and check out his website, because both of those things are an amazing resource of information about all the things that we've been talking about tonight. And just definitely bookmark it, follow it, make sure you get on there. All of our workshops are on the Metro Art Studios YouTube channel, and this one will be as well in about a week. So that's a really great resource to have as well. Our next Artist Work Lab will be the first Wednesday in November, and we hope that you can join us at that point. The topic then will be creating a gallery proposal that a gallery will want. And we've got some really great speakers lined up for that too. So thank you so much to everybody here on the panel.